my lord. I'm grateful.
Arguments on the petitioner side?
Yes, my lord. My lord, yeah. Lords, we have heard, my lord, really scintillating arguments, my lord, from my learned senior colleagues, my lord. And I must say, my lord, as a student of law, my lords, I have been greatly enriched, my lord, by the range of arguments, my lord, which have been placed at the bar.
Yes, we have also learned a lot.
My lord, that my lord, lordships are, my lord, repository of wisdom, my lord, that I don't agree, my lord, as a member of the bar. Lords, on that, my lord, I'll put a caveat. But from my side, my lord, it's been a learning process. My lord, on a lighter vein, my lord, I feel that I am like a batsman, my lord, who has come now. And my lord, there have been fast deliveries, my lord, which have been bowled on both the sides, petitioners as well as respondents.
You were the opener.
Yes, my lord. And my lord, I have to deal with them. Some are, my lord, good length deliveries, which I will deal with, my lord. And some are, in fact, my lord, wide deliveries, submissions made on, my lord's ERP, etc. Lordships will have to actually decide whether they actually fall for consideration. And I'll point that out. And some, my lords, I must say, are no balls, probably inadvertently made, dissenting judgment cited, overruled judgment cited. On a lighter vein, my lords.
There should be some humor in the court.
Yes. I am not objecting, but I'm saying, my lord, that. So I will deal with all this, my lord. So let me start with, my lord, my petition, which is, my lord, writ petition 2880. And, my lord, I appear only in this writ petition. Lords, I don't represent any PIL client. I'm not representing any community. I represent the petitioners as far as writ petition 2880 is concerned.
Yes.
And, my lords, in my writ petition, to which there is no reply, we are almost, my lords, 10 days in the hearing.
No, they have adopted that reply to all the petitions.
My lords, in my case, I have specifically pleaded in paragraph 6, page 5, that we have been using a headscarf right from our admission till, my lords, the GO came and we were stopped thereafter. I just want to point out that there is no reply rebuttal in specific as far as this averment is concerned. Lord, general,
Paragraph 6.
Paragraph 6, my lord. Another paragraph also, not trouble your lordships with that. That's point number 1. Second, my lord, this is a co-ed school. My lord, co-ed college.
When you were admitted.
My lords, this is in the, we are, my lords, in the second year of the college.
Since their admission in the respective colleges.
Yes, my lord.
You have not disclosed as to when you were admitted.
Lords, that is true, my lord. But since their admission, my lord, is 2 years. But lordships will see, we were admitted 2 years back.
First petitioner was admitted is in the first APUC, second petitioner
Yes.
is
Yes. So, my lord, the second point which I wanted to make is kindly see my reliefs. My lords, I have not asked for a general declaration that wearing a headscarf is a part of ERP, a mandamus. I have primarily attacked. Yes, my lord.
Quashing of government order.
That's right, my lord.
Coupled with mandamus to them to permit you to wear hijab and
Yes,
enter
my
the.
lord. Yeah, that's all.
Next.
I'm grateful for that, my lord.
Okay.
Because, my lord, quashing of the government order, according to me, would result, my lord, in the eventual outcome. Prayer 2 is only consequential. So my primary challenge, my lord, is to the GO.
Yes. Next.
Now, my lords, kindly turn to the GO itself. And I will not, my lords, go by, my lords, what is the correct translation, etc. But just have a look at, my lord, the list of documents which have been submitted by the learned AG, and we'll go by that. Just now, relax, don't interfere. No, there's a list of documents. I think it is 47 pages, which was handed over by my lord, sir, my learned colleague, my lord, the learned AG, my lord. And if I can just place the GO itself, which is at page 39. And I must say, my lord, that much of my task as far as this GO is concerned has become very easy, because 90% of the GO has been given up by the learned AG, and I'll show that. Now kindly
90%
turn
of
to
it
page
has been-
39. Has been conceded, my lord. Now the Kannada translation starts, the Kannada version is at page 39, and the English version starts from page 42. My lord, the Chief Justice got it, my lord. My lord, Justice Kazi also has it.
Yes, page 23.
My lord's page 42, my lord, is the impugned order. 42, I'm so sorry, my lord.
Yes.
Page 42 are the recitals, which are not trouble your lordships. Page 43, my lord, are those three judgments. My lords, one Kerala High Court, then my lords, one Bombay High Court, and last, my lord, one Madras High Court. And then, my lords, over the page is the understanding of the state government that as per the judgments, directing not to attend school by wearing headscarf or covering head is not in violation of Article 25. Now, my lords, the learned AG, in all fairness, my lord, on the first day of opening, has clearly said, my lord, and I have noted down not once but 3 times, I've got the transcripts also. He has said that as Advocate General, this is not the purport of the order. This may have been a result of a little over enthusiasm. That are his submissions, my lord. And he has said that it may not have been required. So, my lord, my primary emphasis in my opening was this understanding of the state government in the GO was totally flawed, inter alia, for various reasons. Firstly, I said these 3 judgments do not say that headscarf is not a part of Article 25 right. Now that has been given up by the AG. Number 2, he kept saying, my lord, till the end, and I observed him, heard him very carefully, I will explain those judgments. Till the end, my lord, those judgments, 3 judgments were not explained by any of the council. So, my lord, this part of the GO, according to me, has to go. Second, even if your lordships were to discard the concession made by the AG, this portion of the GO also has to go because it offends the doctrine of dictation in administrative law. Lordships knows, my lord, I don't want to cite judgments, but when a superior authority, the state master, tells the subordinate authority, you do as you want, but I think hijab is not a part of Article 25. That's what this GO says. He says operative portion is innocuous. Master is saying, you decide as you want, but I think, hijab is not a part of Article 25. I say, my lord, in administrative law, this is not permissible. And I don't want to cite judgments, and I'll just give the paragraph numbers, my lord. Just have, my lord's volume 3, if my colleague Shahul can hand over, I'll just give the paragraph. I'm not going to cite it. I'll just give the paragraph numbers of the judgment. Lordships may just make a note. I'm not going to cite because I'm on very limited time. Shahul, if you can just hand over that compilation.
Anyway, acting under dictation.
Yes,
The
yes. I'm
standard
grateful.
pattern in all the
That's right, my lord.
administrative law by Jain and Jain,
That's right, my lord.
IPMSC,
I'm grateful, my lord.
Basu also.
Lord, showing these judgments is bringing coal to Newcastle, my lord. I am like a lamp trying to, my lord, sir, before a blazing sun, my lord, trying to show a wave a lamp, my lord. It's totally inappropriate, but I have to do my justice, my lord, as an officer of the court. So I just wanted to cite these judgments. No, lordships will just have a note. Serial number 1 is 1973 SCC, page 76. If the court master can just hand over that compilation so that the honorable court can just mark it. Because on the index, your lordships may just mark it and leave it, my lord.
All right.
My lord, serial number 1, 1973 SCC, page 76, paragraph 4, my lord, running page 3, and my lord's item number 4, para 23, page 96. That's all, my lord.
Yes.
The third reason, my lord, why this penultimate part has to go, apart from concession, apart from doctrine of dictation, is that there is no material. If the learned AG stand is these judgments are irrelevant, then what is the material to arrive at this prima facie understanding that hijab is not a part of 25? So therefore, my lord, Article 14, Nagaraj jurisprudence will come in. That every administrative decision is not ipsy dixie of somebody, some undersecretary, his understanding. It has to be based on material. So Article 14 is clearly offended. So, my lord, those are the three submissions as far as, my lord, the penultimate part is concerned.
Yes.
Now, my lords, we come to the operative part. Now, my lords, the first part of the operative part, I am not concerned. Second part, let's read it, my lord. It is ordered that in colleges under the jurisdiction of the Department of Pre and University Education, I'm sorry, my lords, I was reading page 44, my lord, of the GO. The uniform prescribed by the College Development Committee or the Supervisory Committee of Management of the respective college shall be worn by the students. If no uniform has been prescribed by the management, then the students shall wear that dress, those dress that goes well with the idea of equality, unity, without affecting law and order of the region. Now, my lords, as far as this line is also concerned, the learned AG, my lord, I've got the transcript. He says last 3 lines were unnecessary. It was not required. And that part also has been considered. Although, my lord, the original lordships have seen Sarvajanika Suvyavaste, it actually means public order. Lord, that has been, my lord, kind of diluted. This one says law and order. The learned AG says, no, I don't need it. In fact, my lord, in the affidavit which they have filed, they say public order. Lordships may make a note. In the affidavit which they have filed, I'll give the paragraph number. Lordships may not be troubled, but paragraph 15 of the affidavit in 2146 of 2022, the affidavit filed by the state, paragraph 15, Lordships may make a note, says that they are doing it on the ground of public order. So, my lords, we have a version, we have a public order ground which is there in the GO, given up by the learned AG in the arguments. In the translated version, a definition which is against the constitution is put. In the affidavit, public order is reiterated. I say, my lord, is this the way a government order is read? So kindly see in that light, my lord, Mohinder Singh, is this at all permissible? Lord, that
Yes, we have seen 1978 Supreme Court 851.
Yes, my
We
lord.
know that.
Yes, my
Go to
lord.
next point.
Just, my lord, just one line in that. Just have a look at, my lord, that compilation which I have handed over. In that, my lord, lordships are aware. Just have a look at paragraph 8. And, my lord, I'll rest my case with that. Just have a look at paragraph 8 at page 17. of this compilation. Justice Dikshit, my lord, has been saying this from day
I have
one.
read that judgment any number of times. Kindly tell me, I can reproduce also.
Yes,
Please
sir.
read.
Yes,
I
sir.
know that.
Yes, my lord.
Yes.
Public orders. Not that it's a extract of the observations of Justice Bose in Gordon Das Bhanji. Public orders.
52 Supreme Court.
Yes, my lord.
1952 Supreme Court, page 16.
My lords, I am literally amazed. My lord, I am literally amazed, my lord. At our age, my lord, we don't remember citations. Your lordships, my lord's memory is phenomenal, my lord. That's something which is God's gift.
Even
my lord.
tolerance also.
Yes. It's God's gift, my lord. Everybody can't have it, my lord. We may learn, but these things are God's gift, my lord. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant, of what was in mind, what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with the reference to the language used in the order itself. So therefore, my lord, on the last part, that now the AG says that there is no public order. It is not a GO based on public order, because I had made lengthy submissions, which I will not reiterate, that public order cannot be a facile ground. State cannot say that I want to exercise my fundamental right, heckler's veto. I have cited all those cases. That public order ground has been virtually given up. Right, my lord? Now we'll come to the point of whether these college development committees, which I refer to as the MLA committees, my lord, have the jurisdiction to, my lords, undertake this exercise as is contemplated by the GO. And your lordships put, my lords, searching questions to us, both to this side as well as to the learned AG. And the learned AG says that, look here, this is Westminster model. MLAs are there, they're public representatives. What's wrong? I say, my lord, everything is wrong. We don't have to go to Westminster. Please have a look at section 143 of the Education Act. So lordships will recall the CDC was a committee which is constituted by the circular of 2014. And I am not challenging the circular. I am challenging the investing of executive functions, statutory functions to this CDC by this GO, that operative portion, which asks the CDC to perform certain functions which are exclusively there for authorities under the Act. Now see, please see page 143. Sorry, my lord, section 143. The state government, my lord, the Chief Justice has it, my lord.
Yes.
The state government may by notification in the official gazette. Lords, I can't make a statement whether this has been notified. So that, my lord, the government has to say. The state government may by notification in the official gazette delegate all or any powers exercised. Yes, sir.
This point is covered by Professor Ravi Verma Kumar. Only repeat.
Yes, no, I'm saying something else.
It cannot be relegated to other than government officers. Because the section says that.
That's right, my lord.
Therefore, we can go.
Yes, my lord. So I am saying, my lord, kindly see if any as may be specified in that direction to be exercised by such officer or authority subordinate to the state government. Now I say, my lord, that an MLA is not an officer, not an officer subordinate to the state government, and that is covered, my lord, by a judgment of the Supreme Court in Ashwini Kumar, lordships knows it, But Lordships may just make a note in that compilation which I have handed over. That is, my lords, item number 6. Ashwini Kumar Upadhyay versus Union of India. 2019 11 SCC, page 683. Lord, that judgment starts at page 117 of this compilation. And my lords, Lordships may just make a note, para 15, page 129.
Yes.
Between, my lords, placitum D and E.
We have followed that judgment.
Yes, my lord.
We have already followed. The division bench has already followed that judgment.
I'm grateful, my lord. Lordships
next.
are aware, then I'll not labor on this. Lordships may make a note. Yes, my lord. I don't want to labor on this. The Lordships are already aware of. So, my
Yes.
lord, lot of arguments have been made while we are on this, my lord, that I have not challenged the circular. I don't need to, my lord, of 2014. All of the learned counsel who have appeared, my lords, have said, where is the challenge to the circular? Mr. Puvaya said it, learned AG said it. I don't need to challenge the circular. As long as the circular, my lord, which prescribes the CDC, remains a Margdarshak Mandal, I have no difficulty. Let them guide, my lord, the college. No difficulty. Let it be, my lord, a guiding force. MLAs, my lord, guiding a college is a good thing. But the problem happens when, my lord, you invest them with statutory functions. So therefore, my lord, as far as this GO is concerned, I respectfully submit, my lord, on all counts, this GO cannot stand, whether the penultimate part or the operative part. And therefore, my lords, I say that this GO has to be quashed. Now, my lords, if the GO goes, I respectfully submit, my lord, that there is no restriction ipso facto on the exercise of a fundamental right under Article 25. My lords, I wanted to develop this argument. My lords, I'll subject because already 4:35, my lord, either today or tomorrow. Because I want to say, my lord, that this question, and I'll just place the proposition so that, my lord, I start from there. And the proposition, my lord, which I want to place, because, my lord, judgments after judgments on ERP have been cited without actually, my lord, telling your lordships, when does the stage of ERP actually come in a constitutional adjudication? And that I want to address. And I want to place, my lord.
1 second, Mr. Kamat. We have read proceeding rules 1977.
Yes.
3 division bench judgments of this court have held.
Yes.
In reply, you cannot raise a new ground.
So I'm not
You
saying
can
a
only
new ground, my lord.
respond to this one.
I am only responding, my lord.
Lies.
I'm only responding to judgments after judgments on ERP. And I am saying, my lord, that ERP question was raised by us only as an attack on the GO. The GO falls, matter ends, my lord.
Okay.
But since this ERP has been raised, my lord, and so many judgments have been pointed out to your lordships, it becomes my duty as an officer of the court to point out the context.
Let's give in writing whichever you want to say.
When you say that if this government order goes, if this
Yes.
government order goes, there
Yes.
would not be any restriction in exercise of fundamental rights.
Yes, yes, my lord, I'm grateful for
Then
that.
what is that fundamental right which you want
Yes,
to
my lord,
exercise?
that's what I want to say. My lord, just give me 2 minutes, my lord, I'll start tomorrow. Lords, what I want to say is this. The question of ERP.
You finish it today. Finish it today.
Difficult, my lord. Lords, I have your lordships have given
We
you.
will extend our sitting. We
Lord,
will
I-
extend our sitting. You finish it today.
Up to your lordships, my lord. My lords, we are here to assist.
Because
your lordships.
we have the experience. We gave you once time. Then next day you take 2 hours.
No, my
Said
lord.
10 minutes. So this time we will not make that mistake.
Lordships are kind enough, my lords, and patient, my lords, in bearing with us. Yes, my lord. My lord, sir, then I will take at least half an hour.
One request we have,
Yes.
Mr. Kamat, we have, you said special bench which Honorable Chief Justice
I know, my lords. I know.
constituted.
I know, my lords. I
We
know.
have tremendous pressure of work on individual side also.
I know, my lords. I know, my lords.
Therefore,
I will not repeat.
we will treat
I will not
every
repeat.
point, take it from us, every
Yes.
point which you have said.
Yes.
We shall be
No,
treating.
I have
it.
absolutely
We
no
do
doubt.
not duplicate and repeat.
No, I will not
Whatever
repeat.
one-
my lord. I will not
One
repeat.
and a half days you have taken.
Yes, my lord. But
Or 1.5, not only before me, even before the division bench. There are rest of the people
Yes,
confined to this. These are
in
not-
rejoinder, my lords, because a lot of interesting points, my lord, important points have been made by the learned AG. I want to rebut that. Now, my lords, on 25, on ERP, I have to say this, my lord, that ERP stage, my lord, does not arise in this particular case, and I'll make that good. My lords, when a challenge is made before your lordships that Article 25 right is violated, the first, my lord, question which your lordships will ask to the state is, where is the restriction? Once there is a valid restriction, a valid law or an order under having the force of law, the second question arises as to whether that law or an order having the force of law impinges upon an essential religious practice. So it's the second stage of scrutiny. I am saying, my lord, that the state has not satisfied that the first threshold has been crossed. Now the order has gone, my lord. What remains is Rule 11 of the Education Act.
95 rules, 96.
Yes, my lord. Yes, my lord.
95.
Rule 11. And the question, my lord,
How can you insist wearing hijab inside the institution which
Correct.
has prescribed certain uniform?
yes.
Now
There's
you
no
say that you have a fundamental right.
Yes,
Now, what is that fundamental right? This is what we want to understand.
I'm grateful, my lords. I'll endeavor to, my lords, assist your lordships on that. Lordships will kindly see that the Education Act and the rules, my lord, at the most, as per the state, my lord, is covered under Article 25(2)(b). That kindly have a look at 25(2)(b), my lord. And that's a very important question which has fallen from the Chief Justice, and we must answer it. Kindly have a look at 25, my lord. This is not a case of lordships have seen this again and again.
Article 25.
Yes, my lord.
Yes.
Lords, this is not a case of 25(1) because the learned AG himself has not put it on 25(1). Although, my lords, Mr. Venkatramani put it on 25(1). Mr.
No, first you have to establish your right. First you have to forget about what AG has said, what the state is saying, or what other respondents are
that is
saying.
why I am just going
First
to
establish your right.
Yes, lords, kindly see. Lords, I have to first, my lord, satisfy your lordships. What is the scrutiny which your lordships will do? Your lordships will not ask, my lord, where is the right? Because Article 25(1) is a
No.
right.
You are insisting.
Yes.
You are insisting to wear particular
Yes.
headdress
Correct,
inside the institution which
Yes.
has prescribed a certain uniform,
Correct.
which does not prescribe the headdress. Now you say that I have a right to wear this headdress
Yes.
because I have a fundamental right.
That's right,
Now
my lord.
we want to understand that fundamental right.
Yes.
You have to establish first before the court as to what fundamental right is being infringed.
I'm grateful, my lord. I'm grateful.
Yes.
So kindly see, my lord, I will cite only 25(1). And actually, my lord, since this very right has been questioned, I didn't, my lords, actually expect the state to question that right. But since that right has been questioned, I will point out from the Constituent Assembly debates this uniform
We
issue.
said you forget about the state.
Very well, my
What
lord.
stand
Since
the
this
state
question-
is taking,
since this
forget
question-
about it.
Yes, since this
You
question,
first establish your right.
yes,
If you are saying that under Article 25(1), you
Yes.
have a right, then
Yes.
first show that.
yes, kindly first see 25(1), my lords.
Yes.
25(1), subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion.
Yes.
Now, my lords, this includes essential practices, non-essential practices. Notes on concepts, I have to be clear. The right, my lords, under 25 is a canopy of rights. I may not even have a
No,
religious right.
Again, these are two things.
Yes.
It is the freedom of conscience and
Yes.
practice of religion.
Correct, my lords. Correct.
Religious practices.
Yes.
Now, which one you are insisting?
Lords, I am saying it is a part of religious practice.
Religious practice.
Yes.
Now you say it is part of religious practice.
Yes.
Now you will have to establish that it is part of religious practice.
My lords, before I do
You
that,
are not on freedom of conscience. You say that wearing of headdress is part of religious practice.
correct.
Then kindly establish that.
Yes, my lord. My lord, I would like to slightly differ on your lordship's approach, because before your lordships question me, where is my right? I ask myself, my lord, where is the restriction? Because 25(2) is very clear. What can be restricted? Just have a look at 25(2).
No, we are not talking about any restriction. We are just talking about your right,
My lords,
which you are insisting for, which you have come before the court.
lords, my right flows from the Quran. I will come to that. But I am saying, my lord,
You said that it is not an essential religious practice. It may not be necessary to establish that it is
Yes.
part of essential religious
Lordships
practice. That
correct,
is why
correct.
we want to know actually what right has been infringed.
my lords, before you come to the right, because in an inquiry, my lords, whether a right has been infringed or not, before seeing the right, my lord, your lordships will have to see whether there is an infringement in the first place. Then the question will come whether it is infringing an essential part or not. Kindly see, my lord, that has been the approach of the court. If there is no valid restriction, my lords, I can't as a private person stop somebody from exercising his religion.
It is a institution which has prescribed uniform.
No, but that
These students are supposed to wear a particular uniform. You
No
are
difficulty, my lord.
insisting to wear
no
more than
difficulty, my
that.
lords. No difficulty. Lord, I am not able to express myself clearly. The submission which I am making is this, that if there is no law providing for social welfare and reform, just have a look at, my lords, 25(2). And that will probably, my lord, that the question which has fallen from the Chief Justice is very, very important. Just have a look at 25(2), my lord. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. No difficulty. For what? Providing for social welfare and reform. So the question which will arise for your lordship's consideration is the Education Act and a rule which is made under the Education Act prescribing uniform, is it a measure of social reform as far as Islam is concerned, as far as hijab is concerned? Kindly see this, Lord. This is I am making a submission. Please.
No, it will not be attracted. It will not be attracted.
My lord, if there is no 25(2) law, my lord, kindly see, I'm grateful for that question. If there is no 25(2),
it is reformatory. The
I just
Article
want to ask that.
25(2) is a reformatory power which has been given to the state government.
My lord, it's
for
not
certain
that,
purposes.
it
is not for the purpose of enacting any education act or something like that and prescribing the uniform.
Yes. My lords, in fact, I'm grateful for that question. My lords, in BJ Emmanuel, because my lord, there are cases and cases. In BJ Emmanuel, my lord, the very same argument that look here, it is a reform, Education Act, the same act. My lord, if at all there was any case before your my lords, if there was any case, my lord, which actually fits in teacher situation, Education Act, students, discipline, and my lords, the argument of reform, national integration, fundamental duty, and the student saying, I don't want to sing the national anthem. It's a part of my conscience right. The question which the Supreme Court asked, my lord, in that case is not to the students. Show me it is an essential religious practice. And I want to show that. Because the law, my lord, has been totally inversed by the state. In BJ Emmanuel, the Supreme Court didn't ask the students, show me your right. I want to show that, my lord. That's very important. The Supreme Court asked first, where is the restriction? If there is no restriction, there is no question of getting into ERP at all. Because ERP is not a restriction on my fundamental right. ERP is a restriction on the state's right under 25(2). That concept, my lords, I have to make it clear. ERP, my lord, in any of our Supreme Court judgment has not said, and I will cite each of those judgments, ERP is not a restriction on fundamental right under 25(1). That concept, my lord, is totally wrong. ERP is a restriction on state's power to interfere with a religious practice. So therefore, my lord, the question which should fall, my lords, according to me, for consideration first is, where is the restriction? And my lords, throughout my learned friends,
What is that restriction? Honorable Chief Justice was repeatedly.
Yes, there is no restriction according to me.
Restriction means
Yes,
restriction must be not in vacuum. It has to be on somebody's right.
correct.
You have come to writ court complaining.
Yes.
Your rights guaranteed that are otherwise guaranteed under 25.
Yes,
Be it according to them, one whatever, or infringed. Honorable Chief Justice is saying,
correct.
when you speak of restriction, certainly it is not in vacuum.
Yes.
It is with reference to a right allegedly violated.
Yes.
That is, where is your right is the question. That is how
Lords,
they have
Lords,
started.
Lords,
That clarification Honorable Chief Justice wanted.
Grateful.
That you have to clarify.
Yes, I'll clarify that. I'm grateful for that question because that's really the heart of the case. My lords, 25(1), my lords, is not a restricted, my lord, a paradigm, my lords. The canopy, the width, and the ambit of rights is not capable of putting in a straight jacket formula. That is, my lords, 25(1). So when I allege that my 25(1) right is alleged violated, first is, my lord, there has to be a restriction on that right. And that right, I am saying, it's my religious faith, it's my practice of faith that I have to wear a headscarf. Now, my lord, when that is alleged to be restricted, the question is, where is the law? And I say, my lord, there is no law. Education Act, my lord, according to me, is not a measure of social welfare or reform for the purposes of 25(2). There is not even one judgment, my lord. I'm sorry, my lord.
Yes.
You're saying something, my lord. Yes, my lord. So there is not even one judgment, my lord, which talks about an alien act and says that, look here, the accidental consequence of some provision in the act is used to justify a restriction of fundamental right. That has never been our jurisprudence. The restriction, my lord, which is prescribed by law has to be very clear. The intention to restrict a practice has to be very clear from the act. The intention has to be evinced not by what the AG says, my lord, not what we say, but by the act itself. Now, my lord, the act has to say that, look here, this hijab is not a practice which is conducive to XYZ reasons, and therefore we are making a law. An Education Act and some unrelated, my lords, uniform rule cannot be a measure of social reform. And I cite, my lords, one or two judgments on that count. My lords may kindly have first.
There is no need for citing any judgment on this. We accept that.
Yes, lords, why I am saying is that restriction, number one, has to have a direct relation to the object which it seeks to achieve. If the object, my lord, is to say hijab is a regressive practice and that uniformity should prevail over hijab, lord, that has to be evident from a plain reading of the provisions of the act and, my lords, the rules made thereunder. And I say, my lord, the Education Act or the rules don't, my lord, evince any such intention. And in fact, my lords, I wanted to cite the Constituent Assembly debates. Kindly have a look at that volume, my lord, which starts at page 447. In fact, what is being propounded today, my lord, was actually propounded, expressly rejected. And what is sought to be resurrected, that we will have a uniformity, nobody should show any religious symbols, would amount to, my lords, sitting in judgment and reversing what our framers, my lord, expressly declined to do. And this is my lord's categorical submission. Just have a look at the debate on, it starts at 447, at page 469. Of
Which
the,
is tell the name of the debater. Was it K.T. Shah or Dr. Ambedkar?
Yes,
If
my
you
lord.
mention the name, I'll write down.
Yes, my lord. Kindly have a
Which
look at page
discussion, of which
470.
date?
My lords, an amendment was moved by Mr. Tajamul Hussain.
Yes.
Tajamul Hussain. The amendment read, kindly have a look at page 470. No person shall have any visible sign or mark or name, and no person shall wear any dress whereby his religion may be recognized. An amendment to this effect was moved, my lord, expressly negatived by the framers of the Constitution to Article 25. Now, my lords, the state, in my respectful submission, my lord, is trying to resurrect this. The court, my lords, by its orders, is trying to resurrect this, and it is not permissible, is my respectful submission.
Yes.
Then, my lords, the next submission which I want to make is on, my lord, this silo argument. That, look here, 19 is a separate right, 25 is a separate right. If you ask for 25, 19 gets excluded. And in fact, the AG, my lord, made an astonishing submission.
But I have replied to him. Quoting
Yes,
R.C. Cooper, I have replied to him. They are
I'm
not
grateful.
watertight compartments.
Yes, Lord. As an officer of the court, I had to, that was repelled in R.C. Cooper, reiterated in Maneka Gandhi, my lords, and lordships will also note in Puttaswamy, my lords, in paragraph 298, just have the citation, my lords, 2017, 10 SCC, page 1, para 298, Justice Chandrachud says that in fact 19 and 25 are together. So therefore, my lord, that silo argument is totally wrong.
Right.
Then, my lords, constitutional morality is cited. And my lord, they say there is a overarching, some kind of an overarching principle of constitutional morality. And that, my lord, will restrict the exercise of a fundamental right. I again say, my lord, that is totally inversing our rights jurisprudence. Constitutional morality, my lord, is not a restriction on fundamental right. Constitutional morality is a restriction on state's power. Every decision, my lord, of constitutional morality, whether it is Nautaj, whether it is Sabrimala, are all decisions, my lord, pro-choice. Kindly make a note, my lord, they are not anti-choice. Today, what the state is saying is that use constitutional morality to defeat choice. That is not the jurisprudence. Constitutional morality, my lords, is pro-choice. Access to institutions, my lord. Access
It's
to
a restriction on
temple.
state power. It's a restriction on state power. Yes.
Yes, my lord. I'm grateful for that, my lord.
Agree.
Then, my lords, a lot of arguments have been made on possibility, my lord, of abuse. That if we do this, then somebody else will do this. A Brahmin boy will turn up. Somebody will turn up with something else. I say, my lord, in constitutional adjudication, we cannot decide on hypothesis. Your lordships will have to decide on the facts. And I will only cite, my lord, that 1983, just give me this, volume 1 SCC, page 147, my lord, this is Sanjeeva Coke, and just mark the paragraph numbers, my lord, paragraph 11.
You have not given in this right compilation.
No, my lord, it's not there. we judges are not authorized to make disembodied pronouncement on serious and cloudy issues of constitutional policy without the battle lines being properly aware of this, my lord. Then, my lords, some submissions have been made on other jurisdictions, and I have to point that out. Mr. Puvaya, my lords, made some submissions on other jurisdictions, and he cited, my lord, European court decisions, etc. Lordships may only make a note as far as Mr. Puvaya's submissions are concerned. He's handed over a written submission at page 20. At page, my lord, 21, he has cited, my lord, at page 14, in fact, he has cited a European court decision from Turkey. And he says, my lord, that headscarf ban was upheld. Now, kindly see, this is a decision, my lord. And subsequently, this decision, my lord, has been overruled. And that decision, my lord, my learned friend will hand over. My lords, of the Turkey Constitutional Court, they have reversed that headscarf ban. My lord, that decision, my lord, my learned friend will just hand over of the Turkish Constitutional Court. My lords, one more point which I want to make. Some of the councils have said, my lord, that this is against international practice. And my lord, it was never my case that this is against international practice, etc. Because that submission was made, I have to rebut that. My lord, there is a parliamentary enactment called the Commission for Protection of Child Rights Act 2005. And if I can just hand over that compilation, that act is there, I will not read it. Shaul, if you can just hand over to the Honorable Court. That act, my lord, talks about rights of children. And the rights of children is defined by Parliament to mean, my lord, the same rights as is granted, my lord, in the Convention of the Rights of Child. And the Convention of the Rights of Child, which is, my lords, ratified by 196 countries, including India, expressly and incorporated into municipal legislation, expressly recognizes headscarves. So, my lord, let us, lords, that's what, my lord, the point I'm making. Just have a look at, my lord, I'm not going to, just have a look at volume 4. And just have a look at, my lord, article 4, first the section, our parliamentary act, page 47 is that act. And this I am not citing as any new point. This is only in response to say that this is a regressive practice. I am showing that this is not a regressive practice. Wearing a headscarf is only a display of diversity. Just have a look at, my lord, the act. It starts at page 47. At page 50, my lord, is the child rights definition. That is section.
You were mentioning
2G.
about Turkish judgment overruling the other earlier
Yes.
view.
Yes.
What difference
Yes.
it makes to us? We have been following
No,
Benin, even when his
I-
judgments are reversed by the House of Lords.
Yes, my lord.
What
No
difference it
difficulty.
makes?
No difficulty, my lord. Since judgments have been cited at the bar, it's my duty as an officer of the court to point out that overruled
All right,
judgments
all
have been cited. That's all.
All right, all right.
Yes, my
Thank
lord.
you. So far,
No, my lord,
as
yes.
recognition of hijab is concerned, nobody is denying that hijab is not a recognized headdress.
No, my
Hijab
lords,
is
what
a
has been argued?
recognized
No, my lords,
headdress.
kindly see. No, my lords, kindly see what has been argued is that it is a regressive practice. It has been argued, my lord, by my learned friends. It is against constitutional morality. We are living in a society which should not be, there should be uniformity. And therefore, no religious display should be shown. Why should a girl be covered with a headscarf? That arguments have been made. In response to that, I am
That is
saying,
with
my lord,
respect to
all of-
dignity.
yes,
That is with respect to dignity, it was argued.
that's right, my lord. That's
It
right.
was not that in any manner.
No, my lord, I
against
just want to
morality.
point that out. And my lords, the other jurisdiction which was cited was France. And lordships, I have given the convention. France and Turkey, my lord, are the exceptions. to this Convention on Child Rights, France and Turkey, my lord. Lordships may make a note, and that's there in the compilation.
All
Then,
right.
my lord, lastly I want to say is this, that what is the net result, my lord? The net result is today people who want headscarves, my lord, or who want a turban, Sikhs, are being denied on the pretext, my lord, of the geo. What is eventually happening, my lord, is that their right to education, which is paramount and an overarching principle, is being, my lord, put on the back burner.
Yes.
And I say, my lord, as a state, you should facilitate, you should create an enabling, my lord's atmosphere in which that right can be exercised. Because lordships will just make a note in
You said
2012, my lord.
positive secularism. You mentioned that judgment.
Yes, my lord.
Constitution.
I am on right to education. No, my lords, I am on right to education. 2012, 6 SCC, page 1. Supreme Court Justice, Chief Justice Kapadia's judgment, clearly in paragraph 32, my lords.
Tell the name of
Says,
the judgment. Tell the name of the judgment.
yes,
We will be
yes,
knowing
my lord,
also.
I'll just give that. 2012, 6 SCC. Society for Unaided, my lords,
Was it
schools.
under the Right to Education Act?
Yes, my lords, that's the constitutionality was challenged, lordships will recall. Yes, my lord, in that context, they examined the right to education, and they said, my lord, that it is a part of Article 25. Just have a look at that, my lord. By judicial decisions, right to education has been read into right to life under Article 21. So a state's decision, my lord, let's say even the rule, if it is eventually leading to a situation where people, my lord, are not going to have the full benefit of the state's policy to open education, I say, my lord, it is challengeable under 21 as well. And lastly, I say, my lords, on ERP, my lords, we had cited, my lords, surahs from the Quran to say, my lord, that this is an essential religious practice. The learned AG, my lord, has said, this is Quran.com, and we can't go by.
First clear your stand as to whether you want to say that it is an essential religious practice,
Yes, my lord.
or
Lords,
whether you want to say that in order to attract Article 25, it is not necessary to see whether it is part of essential religious practice or not.
Lords, I am going to put it on two folds. One, my lord, is that I say it is an essential religious practice. There is no doubt about it. But what I'm also saying is that there is no restriction in the first place. There is no government order. According to me, the government order which puts that restriction, my lord, is totally illegal. My lord, in the absence of a valid restriction, my lords, for the court to get into, my lords, this arena of ERP is strictly not necessary. But if your lordships were to do it, I say, my lord, it is an essential religious practice. I have cited, my lord, Quran.com, and my lords may just have Quran.com is not a translation, my lord. My learned friend is wrong on that. I have given copies of the Quran.com website. It is a compilation, my lord, of various translation of all authors, including Yusuf Ali. Just Shaul, if you can just hand over that.
Authenticity of that.
Yes, that is why I want to show, my lord.
Court in the country has treated it as authoritative text.
Yes, my lord. Just have a
Authoritative
look
version of Islamic law.
Yes, my lord. Just have a look at why I wanted to point out. Just have a look at this is the exact of Quran.com, and the relevant surah is, my lord, 24. And this has all the authors, Abdul Halim, different translation, Pickett Hall, over the page, Yusuf Ali, which my learned friend relied upon, and which I have also quoted in my petition. So therefore, my lord, it is not an unauthorized translation. It is a compendium of translations of all reputed authors. And what I say, my lord, is that the verses in the Quran clearly say, I have
Where it
cited that in
says?
my opening.
Where it says?
Kindly see, my lord, the first one. Just see, my lords, that item 1.
Yes.
And tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what to reveal. They should let their headscarves fall to cover their necklines. Now, my lord, the Arabic word is khimar, and khimar, my lord, is translated, my lord, as a
Khimar is not
veil.
hijab.
Yes, my lord. It's
Khimar
it's
is not hijab.
yes, my lord. Khimar is a veil. My lord, it is like a ghungat, which, my lords, people wear. Now, lordships can translate it as a, in English, my lord, it can be a veil. But a ghungat, my lord, falls on the head and then it comes, my lord, on the shoulders. Huh? Yeah. My lords, the second source. And my lord, just make a note. Justice Kurian Joseph in paragraph 7 of Shaira Banu, which is the deciding judgment, clearly says that what is in the Quran has to be followed, and that is a part of Shariat. That is, my lords, paragraph 7 of Justice Kurian's judgment 2017, 9 SCC, page 1. My lords, the second source of Islamic law is the Hadith. And Hadith, my lord, is also the first source, is not a second degree. That your lordships will see Justice Nariman's judgment in paragraph 54 in Shaira Banu. Just make a note, my lord, that Hadith is as authoritative as the Quran itself. And the Hadith I have handed over to your lordships. Yeah. Come on, my lords, that is it's a collection by Shahi al-Bukhari of the Hadiths, my lord. And this is the, yes, it's mentioned in my writ petition.
Sahih Bukhari.
Yes, Sahih Bukhari. I'm sorry, sir, I'm not well conversant, so please pardon if I have.
Sahih Bukhari.
Collection. Bukhari is the name of the author.
Right.
Yes.
Yes, I'm told, my lord, Sahih is correct and Bukhari is the name of the author. But just turn to the last page of that, my lord. The Hadith stands on the same footing as the Quran, as per para 54 of Justice Nariman's judgment in Shaira Banu. And there can't be any dispute, my lord, as far as this is concerned, as far as what is the importance to be given to Hadith. Now, please see page 2, the last page here. Chapter 12, verse 24, 31 is explained.
How it was practiced.
And how it is practiced. Narrated Aisha, may Allah bestow his mercy on the early immigrant women when Allah revealed and to draw their veils all over their Juyu Bihinna, their bodies. Kindly see, my lord, their faces, necks and bosom. They tore their murut, woolen dresses or waist binding, clothes or apparels, and covered their heads. This is what I'm saying, my lord. This is the practice which is, my lord, the first degree of source for Islamic law. And there is no dispute, my lord, as far as this hadith is concerned at all. And my lord, lordships are aware, my lord, Aisha is the wife of the Prophet. And my lord, lastly, none of the councils, my lord, appearing on the other side, have disputed two judgments of the Kerala High Court, single judge, division bench, and also Madras High Court, my lord, which has gone through, my lords, these Islamic verses, scriptures, and has come to a conclusion that parda or a burqa may not be an essential practice, but a headscarf is. And my lord, my learned friends have not cited a single decision of any court in the country, my lords, saying that headscarf is not. And I have cited, my lord, a minimum of 3 decisions of Indian courts, which, my lord, categorically say that headscarf is a part, essential part of Islamic religion. My lord, so therefore, my lord, I respectfully submit that, yeah. My lord, therefore, I respectfully submit, my lord, that the GO which is the basis for our action before your lordships, is totally illegal. There is no restriction, legal restriction, my lord, for exercise of Article 25(1). And I am sure, my lord, lords, I am reminded, my lord, to end with what, my lord, Dr. Ambedkar said, my lord, when he actually finished, my lord, drafting the constitution along with the other lords, fathers of our constitution, and he made a speech, lordships are aware. He said, my lord, we may have a great constitution, but the people who implement it are bad, my lord. It will turn out to be a bad constitution. And I dare say, my lords, the way the state has implemented this, a good constitution, my lord, has been totally frustrated. But I am equally sure, my lord, that we are in the hands of a constitutional court, my lord, and we will make our constitution work. And I'm sure, my lord, that justice will prevail. I'm grateful for a very patient hearing, my lord. Lordships are
Thank
sitting
you.
till 5. I am really grateful, my lord.